Hey Law Nerds, this is Professor Tracy from Law Simply Explained, back with another video, this one on the subject of offers. So we looked at mutual assent in the previous lesson, which we said is a broad overview of offer and acceptance. We said that in order to have a contract, not only do we need consideration, that is, we need to know that there's an exchange between the parties and consideration is the thing that is being exchanged and it must be of legal value, but we need mutual assent. We need offer and acceptance to the same deal. So let's dive in and take a look at offer and acceptance. But before that, let's do a review, look back at where we've been so we can move forward with all of that firmly in mind. As we said, we're looking at contract formation, which involves three elements: offer, acceptance, and consideration. Our focus thus far, or primarily I should say, has been on consideration. And we said that consideration has two primary parts. First, it's a bargain for exchange in which the promisor's promise must induce a detriment from the promisee. And we said that the promisee's detriment must be what induced or motivated the promisor to make her promise in the first place, such that we have an exchange with each party bargaining for what the other party is providing, either the promise or the performance. And so we said also that that which is being exchanged must be of legal value. And that is defined to mean that it's either something of benefit to the promisor or it's a detriment to the promisee. Remember, when we talk about a bargain for exchange, it's an and, not an or. We must have both the promisor's promise inducing the promisee's detriment and the promisee's detriment inducing the promisor's promise. So with the consideration rule in mind, remember, we spent an awful lot of time running through sub-rules to consideration that fall under the broad topic of consideration. We looked at conditional gifts, which we said are not consideration. A promise of a conditional gift remains a gratuitous promise because we said although it may induce a detriment from the promisee, that detriment is not what induced the promisor's promise in the first place. We said that with adequacy of consideration, that the general rule is that adequacy is not an issue. We made sort of two qualifying statements, which is one, if there is a gross disparity in the things being exchanged by the parties, meaning when I say things, in the relative values of the things being exchanged, that still it doesn't mean the element of consideration isn't satisfied, but it raises a red flag for us that there may be a defense that applies. We will look at defenses in detail later. The other thing we noted with adequacy is that if the consideration is merely nominal, then it does not in fact satisfy the element of consideration. And the reason for that is, depending on which side this quote-unquote nominal consideration is, we don't believe that the promisor is making the promise or is induced to make the promise because they want a quote nominal detriment from the promisee, or vice versa, that if and what the promisor is promising is merely nominal, then we don't believe that's what induced the detriment from the promisee. So that's adequacy. We then looked at illusory promises where, remember, it's a situation where one of the alternatives that's being promised is essentially not a commitment, right? An illusory promise means it looks like a commitment, but it's not, such that if we step back, we know that one of the alternatives that the promisor has reserved to themselves is to do nothing, to not actually follow through on anything. And if that's the case, it's an illusory promise and the element of consideration isn't met. We said that past consideration is does not satisfy the element of consideration either, because when a promise is made in recognition of something that's occurred in the past, then the promise is not what induced it, right? It's merely recognizing something that's already occurred, right? The promise couldn't have induced something from the promisee or something the promisee did in the past because it's already occurred. That promise is merely recognizing it. So past consideration does not satisfy the element of consideration. Similarly, and often closely related, but not always, is the notion of moral obligation. Simply because something is the right thing to do, or that somebody feels compelled to promise something in return for some benefit that was bestowed on them, doesn't satisfy the element of consideration. Even if our heartstrings are being tugged, right? And we feel like, well, that, if we're ever going to enforce a promise, we should do it for this reason because, golly gee, it's the right thing to do. It's the fair thing to do. It's the just thing to do. But moral obligation does not satisfy the element of consideration, no matter how badly or much we want it to. That doesn't mean that might figure in for one of the consideration substitutes, but in terms of does it satisfy the element of consideration for purposes of creating a contract, the answer is no. Then remember that if a party already has a duty to do something, either because they have an existing contract with the party or with a third party, or because the law requires them to do something, then a promise or a commitment to do something that someone is already committed to do doesn't satisfy the element of consideration, right? That's the pre-existing duty rule, and it comes up in the context especially of modifications, where you need to keep in mind the differences between how the UCC deals with modifications and the common law. Recall that the common law requires two things. It requires additional or different consideration as well as good faith, and the UCC requires only good faith, no need for additional or different consideration. So we also spent the last two lessons looking at consideration substitutes, but remember long ago we looked at the idea of the promise of a gift that has been executed, meaning that the gift's been given. It doesn't matter that that promise of a gift was gratuitous when it was made. If the gift's been given, then we're done, right? The fact that it was gratuitous when made is now irrelevant. The giver of the gift can't come back and go, well, when I made the promise, it was gratuitous at the time. Nope. If it's been executed, it's been executed. The fact that it may have been gratuitous at one point is irrelevant. So we also looked at promissory estoppel. Remember that the essence of promissory estoppel is detrimental reliance. And the idea is that a promisor makes a promise that induces a detriment from the promisee, meaning it induces the promisee to take action or refrain from action in response to the promise, and that reliance is something that would be reasonably foreseeable or expected by the promisor when she made a promise to the promisee, and that ultimately that reliance, has been detrimental to the promisee, such that we now have to say, well, then does justice require the enforcement of this gratuitous promise, even though it's gratuitous in the first place? Remember that the doctrine of consideration serves as a way for us to sort out which promises are legally enforceable because they're contractual in nature, and those that are gratuitous, and those that don't have consideration are gratuitous and therefore are, as a general rule, not legally enforceable, but we may be able to fall back on one of these consideration substitutes, which could be that there's an executed gift or promissory estoppel, or plain old standard restitution, by which we mean a quasi-contract or implied in law contract, which, remember, not only doesn't require the existence of a contract, but doesn't require a promise at all. It simply requires that the plaintiff bestow a benefit on the defendant, and the defendant has knowledge that that benefit has been bestowed and that they have retained that benefit, such that we would ask, would it be unjust for the defendant to retain that benefit without compensating the plaintiff for the value of it? So that's what we might think of as standard restitution or quasi-contract or implied in law contract. And then we talked about promissory restitution, which is based on the idea, which is exemplified by the case of Webb v. McGowan, which is the idea that there's been a definite and substantial benefit bestowed by the promisee on the promisor, and the promisor made this promise in recognition of this benefit, substantial and this substantial and significant benefit that's been bestowed on them. They're recognizing it, and we're now going to ask, does justice require the enforcement of that promise? We know that as a general rule, as we just said when we looked at our consideration sub-rules, the answer is no, right? Because that promise would be based on something that occurred in the past, that the promisee had previously bestowed a benefit, which we know past consideration doesn't satisfy the element of consideration, or it will be based on the idea of moral consideration, which again does not satisfy the element of consideration. But this equitable doctrine says sometimes when justice requires this, that this equitable doctrine will work. Well, when does justice require it? The restatement tells us, well, when the benefit is substantial and definite, as it was in Webb, where one guy is sacrificing his life, or at least his well-being, right? He's crippled, in order to save the other guy's life. And then we're told that it also then depends on the formality of the promise that's made by the promisor in recognition of that definite and substantial gift or benefit, that was bestowed. And then we're going to look at, was this promise performed in any way as it was, remember, in Webb, that it had been paid out for several years? And then was there any reliance on that? Remember, those are factors. We don't need all those, but those are factors that the restatement gives us to consider when we're asking, does justice require the enforcement? And then remember, with promissory restitution, and with restitution, right, standard restitution or quasi-contract implied in law, that if it's truly intended as a gift, then it's not, restitution can't be sought in either form. And then with promissory restitution, we said that there's a limitation in that the promise that's made by the promisor will only be enforced up to the value of the benefit bestowed by the promisee on the promisor. And remember, it must be very direct, right? That the promisee is in fact the person who bestowed the benefit on the promisor, not that the promisee bestowed it on somebody else. So those are our consideration substitutes. So those are the things we've looked at so far, but let's jump into looking at offers in particular, since that's the focus of this lesson. Remember, I talked briefly in the previous lesson about what an offer is. In a general sense, an offer is simply one person or party that is proposing a bargain or an exchange to the other party. That it's simply saying, hey, here is an exchange that I am proposing to you, Miss Offeree. And so when we look at this rule, though, from sort of what I will say is a combination of rules from the restatement that we're putting together here, we can see this is how the rule comes out for an offer. It's a manifestation of a present intent to enter into a bargain that's communicated in certain and definite terms to an identifiable offeree. And then hearkening back to what we said about the objective theory of contracts in the previous lesson, that manifestation must be so made that a reasonable person in the shoes of the offeree would understand that all she needs to do is to assent, and then there'll be a contract between the parties. So we can chunk that, right? Break it up as we've done with our previous rules. So we know, one, we need a manifestation of a present intent to enter into a bargain. A manifestation, just as we've talked about in every other time we've used that rule, is an outward expression. So it is going to be words or conduct, that it's communicated to in certain indefinite terms, that the terms of the offer are nailed down, that it's communicated to an identifiable offeree. And we'll see that means either a particular person or group of persons. And then we have this, what embodies in element 4, the objective theory of contracts. Would a reasonable person understand this manifestation as being an offer, such that all they would have to do is agree, and that would form a contract? So let's break that then into these specific elements, and we'll walk through them. So let's look at number 1 here, a manifestation of a present intent to enter a bargain. What does that mean? Well, let's look here at Bob and Bo. So here we've got Bob thinking in his head, I sure could use some extra money. I bet I could mow Bo's lawn for $25 this Friday. So all Bob is doing is thinking this in his head, this possible proposal in his head. That's not an offer, right? There's no manifestation there at all. It's just something he's thinking in his head. But what about this one? Hey, Bo, I've been thinking about selling my boat sometime. What do you think? Well, now he said something. Bob has said something, but it's not a manifestation of what? Of a present intent to enter in a bargain. He's just saying, I've been thinking about selling my boat. That's all he's saying. He doesn't have a present intent to enter into an exchange. So again, not an offer. What about this one? I'll pay you $5,000 for your boat. I made a lot of improvements and poured a lot of money into my boat. If I were going to sell it sometime, I couldn't part with it for less than $16,000 cash. So here, you got to look at where we stand. And looking here, let's particularly look at what Bob has said. It's still not a present intent to enter into a bargain. If there's any equivocation where he's saying, if I were going to sell it sometime, I couldn't part with it for less than $16,000. He's not saying, I intend to sell it. And he's just saying, if I were ever to consider doing that, I would want at least $16,000 cash. So it's still not a present intent to enter into an exchange. That's going on here, right? So Bob still hasn't made an offer. So what about this? Hey, Bo, I keep forgetting to drop off my old couch for you. I'm sorry. I promise I'll swing by after work and drop it off at your house. And so here, you'd say, does he have a present intent to do something? Yes, but it's not a bargain. We can hearken back to what we said in previous lessons. This isn't an exchange, right? This is just him saying, I'm going to drop off my free couch for you. He has some present intent to do something, but it's to make a gift, not to enter into a bargain. So this too is not an offer. So what about this one? Hey, it's Bo, the bowcaster, the Bonana, the Bowmeister, the bow and arrow. Take a bow. Stop. I know how this goes. I'm so not in the mood. What do you want anyway? No, I was just going to ask if you want me to mow your lawn on Friday afternoon for $20. So now we have an offer from Bob, right? If we go back and look, he's made a manifestation. It's spoken words. It's of a present intent, right? He wants to enter into a bargain today, which I'm recording this on a Saturday, and so Friday would be next week, saying, I'll mow your lawn on Friday afternoon for $20. He's proposing an exchange. He has a present intent to enter into a bargain, even though the performance is not going to take place for almost a week from now. But there we have a manifestation. It's of a present intent to enter into a bargain. So here we do have an offer as far as we're concerned, right? We'll look at the other elements, but as far as the first element's concerned, yes, we have that, and it looks like an offer. So let's look at the second element of an offer, which is that it must be, that manifestation must be in certain indefinite terms. So not only must it be an outward expression, not only must the offeror, the person making the offer to the offeree, not only must they have a present intent to enter in a bargain, meaning an unequivocal desire to enter into an exchange that they're expressing to do it now, it must be laid out in certain indefinite terms. And we'll see we need to be a little bit careful with this particular element of an offer, but let's walk through it, right? So, because there's this question that lurks, which is we have to decide, well, what do we mean by certain indefinite terms? What the restatement tells us is for something to be reasonably certain, for an offer to be reasonably certain, and remember, when we talk about an offer, particularly at common law, but equally true even under the UCC, although things work differently, and we'll get to that in a future lesson, but particularly in the common law, remember that the offer is laying out the terms of the contract, of the exchange between the parties. The only thing that an offeree does is accept, is agree to those terms. They're not changing them, because if they do, we'll see that is something other than an acceptance, right? But if there's offer and there's acceptance, then the offer has laid out the terms of the deal. Well, so in order for us to say something is truly an offer, then we need to have enough there such that we know what the terms of the contract will be if the offeree agrees, if they accept. So we say it's got to be reasonably certain, which according to the restatement means two things: that it is certain and definite enough that a court will either be able to determine breach, which means they'll be able to look and say, can we determine if the parties have or have not done what it is they were supposed to do under the contract, what it is they promised to do under the deal. And or is a court able to fashion a remedy? Meaning, if they were going to give an order of specific performance, would they know what it is they are to order? Or if they're going to award money damages, is there a basis for determining it? Is it set enough for them to be able to figure out where it is financially that the parties expected to be if everything had gone as planned? So it needs to be certain. And the guiding principle here is we think about, well, specifically, what does that mean? And if we get down to, well, what are certain indefinite terms? Our guiding principle here is the intent of the parties. What a court is going to look at is say, does it appear that the parties intended to enter into a contract? Because if it appears so, then a court is much more likely to imply terms that may be missing, assuming there's a basis for doing so. We'll see that the rub here is that the more uncertain, or the more terms that are missing from an offer, and therefore from any potential contract that would allegedly be formed from this offer, then the less likely it is we would even say that it's an offer, right? Because we can't nail down a contract because we wouldn't know what it is the parties are supposed to do, or we wouldn't know financially where they expected to be, or what we would order the parties to do. But if we have enough there, then a court may imply terms, assuming there is some basis that they could reach out and rely on to do that. So if it's clear that the parties wanted to form a contract, then the court is going to try to make that happen if it can. And so when we look at certainty and intent to contract, again, if the parties intended to contract, then the court will try to do that. But one indication of intent is how certain is this manifestation that the offeror made? The more uncertain, the more we would say they're just talking. It's just preliminary negotiations as opposed to an actual offer. So the less certain, right? The less certain, which is just the inverse of what we said, then the more likely it is they're just in preliminary negotiations. The more certain, the more likely it is an offer, and vice versa. So that's how we look at these things. So let's look at Bob and Herman. No, hi, Herman. It's been a while. Yeah. So what brings you this way? My wife and I have tickets to see Hamilton, and we need someone to watch Little Henry. So right now, they're clearly just talking, right? Herman's saying, I've got tickets to see Hamilton, but we can only do that if someone watches our kid Henry, right? So they're clearly way on the side of just chatting. Huh? Are you seeing it at Artist Naples at one of the shows in January? Yeah, on Saturday, January 11th, from 2 p.m. to 6 p.m. But we can't go unless someone can watch Henry. So they're still just talking, right? He's saying, yeah, we've got tickets to go here at this location, but we can't go unless someone can watch Henry. I mean, you could say, is he beating around the bush? Sure. Herman, I'd be happy to watch Henry on Saturday, January 11th. I'm certainly available. Most Saturdays, I don't do much. Really? That's great. Since the show starts at 2 p.m., could you be at my house by 1? I expect my wife and I will be home by about 6:30. So it's likely still talk, right? You could say, we've got the time, right? We'll look at, what are the essential terms? This may be enough. We're getting close to an offer here. But, you could say, well, we don't know how much exactly, but that's all that's missing. Assuming there's some objective basis for telling us what's the market rate for watching somebody's kid, then maybe it would be an offer, right? Because do they have a clear intent to enter into bargain? It's pretty darn close, but maybe we could say it's still just preliminary talk, preliminary negotiations. That works for me. Oh, super. Okay, then. So I'll pay you $50 to watch Henry on Saturday, January 11th from 1 p.m. to 6:30 p.m. Does that work for you? So now Herman's clearly made an offer, right? Like we can go back and look at it and say, we know who the parties are, right? It's Bob, it's Herman. We know the timing. It's Saturday, January 11th from 1 to 6:30. We know that Bob's going to watch. We know what he's going to do, the service he's going to provide. He's going to watch Henry for that time, and he's going to be paid $50. So the terms of the bargain are completely nailed down. There's no question that Herman has made an offer at this point. And we can say a reasonable person in the shoes of Bob would think, all I've got to do is agree, and then we've got a deal, we've got a contract, right? So, and remember, you might say, why do we care when we've reached that point of an offer? Because up until the parties reach a point where one of them has made an offer, there's nothing of any legal significance going on. It's not until there's an offer that the offeree has the power of acceptance. It's the offer that creates in the offeree the power of acceptance. That is the legal effect of an offer. And we'll see that it occurs upon notice to the offeree. So we need to know when we've reached that point where the offeror has made an offer, communicated an offer to the offeree, because that's when the legal effect occurs and we've created in the offeree the power of acceptance. Until then, we've got nothing of any legal significance going on. They're just talking. We've just got preliminary negotiations. So let's follow this up, right? Herman says, now, super. Okay then, so I'll pay you $50 to watch Henry on Saturday, January 11th from 1 p.m. to 6:30 p.m. Does that work for you? So,
kaboom! I have the power of acceptance.
That sounds good. I'll be there. So at that point, Herman created what we said was a clear offer. He obviously has notice because they're talking to each other. They're physically in the presence of each other. So he obviously has notice. It has the legal effect of creating the power of acceptance in Bob, and now he's accepted. He said, sounds good, I'll be there. So they have a contract. Is it effective? This is what we just said. It creates in the offeree the power of acceptance, and when that occurs, that creates this ability to accept. So if all Herman had done is go, I bet I could pay Bob $50 to watch Henry on Saturday, January 11th from 1 p.m. to 6:30. This is just like we said before. It's not a manifestation of a present intent to enter the bar. Herman's not manifesting anything, so there's no notice to Bob, right? So there's no notice, no power of acceptance. Now here, Herman's writing a letter. Dear Bob, I will pay you $50 to watch my boy Henry on Saturday, January 11th from 1 p.m. to 6:30 p.m. Your friend, Herman. So he's writing a letter, but if all he's done is put it on paper, there's no notice to Bob if he hasn't sent it and Bob hasn't received it. So there's still no acceptance. If Herman is now talking to Barb and says, Barb, I'm going to ask Bob if I pay him $150, whether he'll watch Henry on Saturday, January 11th from 1 to 6:30 p.m. Guess the price increased there. But so there, he's communicating it to Barb, but Bob still doesn't have notice, right? No notice, no power of acceptance. So here, Herman's now saying this directly to Bob. Bob, I'll pay you $50 to watch Henry on Saturday, January 11th from 1 p.m. to 6:30 p.m. Are you interested? So there we said that's notice. We just went back to where we were. That creates in him the power of acceptance. Well, what about this situation where it's being communicated through Barb? And we'll talk more about this kind of situation. But here, it's Barb communicating to Bob. Bob, I heard Herman has offered you $50 to watch Henry on Saturday, January 11th from 1 p.m. to 6:30. So we'll see that does count as notice when we're talking about the initial offer. It can be communicated through a third party like this. So that would work. So what about though, so we were talking about ostensibly about reasonable certainty and saying, what does it need to be? We took this sort of tangent into notice, but what do we mean about reasonable certainty? We said that our sort of North Star or guiding principle is the intent of the parties, and that the more uncertain something is, the less likely it is to be an offer, and the more certain it is, the more likely it is. But what kinds of terms are we looking at? And you want to be careful here, even though I am stating this in pretty emphatic terms, it is not the case that if one of these is missing, that means there's no way there's an offer. But typically, when we talk about essential terms, these are the terms we're talking about. We need to know who the parties are going to be to the contract, right? So the offer has to make clear who the parties are. That could be as simple as, they're the two parties being communicating, talking with one another, like with Bob and Herman. We need to know what the subject matter is. What's the subject matter? If it's a service, what's the service? If it's a piece of property, do we have enough to identify the particular piece of property? It doesn't need to necessarily be, an exact legal description, but enough to identify what the piece of property is. If we're under the UCC, do we know what the goods are? Is it corn? Is it an airplane? Do we know what the price is that's being asked? And then do we know the terms of payment? Meaning, how is it going to be paid? Is it going to be paid in installments? Is it going to be paid all at once? What's the timing of the payment, etc.? And then what's the timing of the performance? So when will the property be transferred to the buyer? When will the service be provided to the homeowner or the owner of the car? Or when will the goods be delivered? Now, again, do not hear me to be saying that if any of these are missing or unclear, then that means for sure it's not certain, that it's not certain and definite, and therefore we don't have a contract. That is not the case. Even under the common law, if it's clear that the parties intended the contract, and then we would have to say, well, is there some way from which a court, assuming they intended the contract, then is there some way the court could figure out what these terms are? For instance, with the price, say we have a rental agreement and they didn't establish what the rent would be each month, then there probably is a clear objective way external to any communication to the parties we could look at, which is what's the going rate for, say, a one-bedroom apartment in this particular geographic geographic region. So we could probably figure it out. There's some things you may not be able to figure out, particularly if we have no idea what the contract is about. If we don't have any subject matter, then it's hard to imply, even though you're like, well, it appears that the parties intended a contract about something. If there's no way to know, then we can't do that, right? There's no reasonable way to do that. In terms of timing, again, that's a thing you can likely imply, assuming it's not so clear that, it's not clear from the facts that, well, we really need to know the particulars, and just saying it's a reasonable time may not be good enough. But often that is good enough that you could say, well, it's a reasonable time. That just depends on the facts and the circumstances. So we can figure it out. We can imply what the timing of things would be. So don't think that just because something is missing here means that there's no way it's certain enough to be an offer and therefore ultimately to be a contract if the other party agrees. But these are the terms, and if they're missing, any of these are missing, it should at least raise a red flag in your brain from which you would say, well, the fact that if multiple ones of these are missing, then that likely tips in favor of saying this is so uncertain that it's hard to believe that the party intended to make an offer at this point. They're probably still just chatting. It's just preliminary negotiations. But these are the essential terms we're talking about. Now, what about implying terms? So when we look at this, the common law, as I just said, if you're looking at this chart, that under the common law, unlike the UCC, that there's a difference here, which is that the UCC has specific provisions that we call gap fillers. So that the UCC specifically says if no time is laid out for the delivery of the goods or for payment, then what's the time? We imply a reasonable time, which is we're going to look at all the surrounding facts and circumstance, the nature of the goods, the nature of the market we're in, and the transaction involved, and say what's the time. And the UCC also says with the price. Well, what's the price? It's a reasonable price. The common law, although it doesn't have gap fillers, does do something similar, which is to say, if it's clear that the parties intended the contract, the fact that there's a timing missing, the timing term is missing, or the price is missing, if there's some way of figuring out a reasonable time or a reasonable price, then they're going to still be willing to do that, despite the fact that there may not be, or there is not, particular provisions in the common law that provide gap fillers like the UCC. So when we look at the little trees here and the little the wrench and the hammer there, the trees are saying if it's property, we need to be able to identify that, right? If it doesn't provide any identification, there's no way for us to know what the property is, well, then there's no way to imply that, right? So that's why there's an X. If it's a service, again, if it's not identified and we have no idea what service they're talking about, we can't imply that. And realize with the UCC, it's not about property or services, it's about goods, which is the crate there with the fruits and vegetables in it, which is, keep in mind that under the UCC, there's no gap filler for the identity of the goods or for the quantity of the goods, which is that 1 and 2 with the plus and minus, which is why there's an X there. But then the final thing with the warehouse there with the crates and the boxes, that is what's the place of delivery of the goods. Now, that doesn't come up under the common law because we're not talking about goods and delivery of those goods. But under the UCC, it says if there is not a place of delivery identified, then there's a gap filler that says the place of delivery is where the goods are. So that could be the seller's place of business, but if those goods are not at their place of business, but at a warehouse, some third location, then the place of delivery would be there. That's where we imply it. So that's the gap filler. So that's the basics of implied terms. So let's look at this communication between Bob and Bo. Bo, every time I read the news, I get depressed. What's with all the name calling? Can't we talk about the actual policy issues for once?
Yeah, I just stopped reading it altogether. Ignorance is bliss, my friend.
Really? Who am I going to talk to about politics and wars and famines and death and taxes? Way to add to my sadness.
Oh, I don't know. You might be able to persuade me to get back into the news. Ice cream cone is sounding pretty good right about now.
Not above a quid pro quo, eh?
Let me put it plainly, Bob. If you'll take me out for an ice cream cone, I'll start reading the news again and we can resume our chats.
You got a deal, my friend. Let's go for some ice cream then. So here, keep in mind, yes, there's a presumption. If this is a social situation, it probably wouldn't work, but set aside that presumption. And we're looking at this and saying, what's going on here? There's an exchange that's being proposed, right? Which is Bob is saying to Bo, I will buy you an ice cream cone. And Bo's saying, in exchange, I'll start reading the news again. And you might look at this and say, well, we don't know everything that's going on. We know the parties. We know what each is promising in terms of Bo's promising a service of sorts, that he'll read the news again, and Bob's promising a good of, I'm going to buy you an ice cream cone. But we don't know the timing. We don't know, well, how much is it going to cost, right? Like, what is the price of this ice cream cone? Well, it doesn't really matter, right? Because we can imply from this, they clearly have an intent to enter into an agreement. And so we can imply the time based on all the surrounding circumstances. It appears to be, based on the conversation, that a reasonable time would be right now. And that in exchange for him taking him out for this ice cream cone, that he would then start reading the news again. And the price of the ice cream cone, I assume it's whatever the reasonable price of an ice cream cone is, the going rate. Yes, there's a range there. There's cheaper places, more inexpensive, but there's a pretty obvious range of what an ice cream cone costs. And so the fact that some of the specifics might be missing here are not going to kill this, right? Again, setting aside this presumption that any sort of social interaction like this wouldn't create a legally enforceable agreement. So yes, I'm setting that aside, but setting that aside, it should work. Now, what about this element of an identifiable offeree? I mentioned in passing that it's got to be that this manifestation of a present intent to enter into a bargain that has reasonably certain terms or certain indefinite terms must be directed to a person or group of persons. And that if it's not, then it's typically what we call an invitation to deal or a solicitation of offers. They're asking for people to make them offers rather than themselves making an offer. And so keep in mind here, though, that when we say a specific person or group of persons, it doesn't have to be by name. There just has to be enough for us to identify who's this group of people or who is the individual. Like if I were sitting in the classroom and I said, the next person who comes through the door, I promise that I will mow their lawn for $20, then that works because we have enough criteria to know who the offeree is. It's the next person who walks through the door, even though I didn't name them specifically. So let's look at an example. Bo here has put up a sign that says,
Lawn Services, call Bo, 239-555-1212.
Bo, I accept. So that doesn't work, right? That Bo never made an offer because if we go back, it's just a sign where he's soliciting offers or it's an invitation to deal. He hasn't said anything in there specific, right? We don't know what the price is. We don't know the timing of anything. We don't know even exactly what lawn services are. So Herman coming up and going, I accept, doesn't work because Bo never made an offer. So we can't have a contract. Bo, I saw your sign. I will pay you $30 to mow my lawn and trim my hedges on Friday afternoon.
Sounds good, Herman. I accept.
So now it's Herman who made an offer and Bo that accepted, right? So the sign that Bo posted was saying, come talk to me. I'm soliciting offers. I'm inviting you to come deal with me about lawn services. So that's what Herman's responding to. And Herman has made the offer and then Bo accepts it. So it's done, it's had its effect. That's what the sign did. The sign wasn't the offer. Herman's response to the sign was the offer. So what about this last element of a reasonable understanding of the offeree? The contract will result if accepted. There, remember what we're doing. We're using the objective theory of contracts, which we talked about in the previous lesson, which is that we're asking, would a reasonable person looking at the manifestation coming from the alleged offeror, would they look at this and say, it appears that this is someone proposing a bargain to which all I have to do is agree and a contract will result. That's what we need to know. Is that a reasonable way of interpreting the manifestation? Using our basic tools of interpretation, looking at the manifestation, if it's spoken word or written word or conduct, giving the ordinary meaning to the words, giving the technical meaning to technical terms, and looking at all the surrounding facts and circumstances and saying, does it appear that the offeror indeed has a present intent to enter a bargain, right? We're looking at the manifestation. Do they have a present intent to enter a bargain? Is that bargain laid out in certain indefinite terms such that it's reasonable for the offeree to think this, that it's a reasonable thing? Because again, the more uncertain it is, if a court were to say, we don't even know how we would determine breach because we don't know what you're supposed to be doing or what the piece of property is or what the goods are. We can't even know whether there's a breach, or we don't even know what the remedy would be, right? We can't order you to do something because we have no idea what it is. And we don't know financially where you expected to be. And this is not a present intent to enter a bargain. It's someone saying, I'm thinking I may do this, sell my motorcycle in the future. Or I'm thinking about starting up a lawn business sometime, right? That's not reasonable, right? You're looking at all these things and saying, is it reasonable? And again, is it to an identifiable offeree? If, for instance, after class, two people are talking to each other and one of them says, hey, I will sell you my contracts book for $25 at the end of the semester, then if I were to be like, hey, that sounds good, I'll buy it. Well, you got to look at that and say, well, it wasn't addressed to me. I am not the identifiable offeree. It's not reasonable for me to think I have the power of acceptance. It's only the person who is the identifiable offeree that has the power of acceptance, that they can reasonably think that. So it's with all those elements in mind that we would have an offer. Let's quickly consider ads, which we kind of hit on with Bo's sign, but advertisements raise this question, right? Which basically Bo's sign was, but typically when we look at an ad, the general rule is that it's not an offer, but that instead it's an invitation to deal or a solicitation of offers. And that's generally because either it's not certain indefinite, we don't know all the terms, or that it's just addressed to the general public, not to a particular enough of a group that we would say it's to an identifiable class of offerees or to a particular offeree. Or it's because we just know it's under circumstances where we would say, no, that's not a reasonable way to interpret the communication. There are exceptions, though, that if it's specific enough, that there's not this weird problem of if we treat this ad as an offer, then there's going to be this problem of over-acceptance, right? That all of a sudden the seller here or the person who placed the ad, if anybody calls them up and accepts, they suddenly have a million contracts that they can't necessarily fulfill them all. Then we might consider it the ad an offer. It's going to depend on the circumstances and the specificity of the ad, whether we could say, well, maybe it's to an identifiable enough group of people. And also, there are a lot of consumer protection laws that come in this context where either courts or the state legislature or Congress may say you can't engage in a bait and switch, like you can't advertise one thing, have people come in and say, oh, we ran out of that, or no, there's no cars on the lot at that price, but here's this other one at a higher price, that we try to protect consumers from being taken advantage of, so we may actually treat an ad as an offer under some sort of consumer protection law because of that. So we have this general rule. There are exceptions. So let's look here. If Bob has this Shoe Depot ad he runs in the paper and says, all shoes 50% off Saturday, November 19th. So here, this is just to whoever reads the paper, and it just says all of our shoes are 50% off. It's not very specific. We don't know which shoes. It says all shoes, but it's just to whoever's reading the paper, right? And we don't have, the shoes aren't identified with any specificity. We don't really have the prices completely nailed down. It's very general. Right? And there would be a huge problem of over-acceptance. What if he sold all his shoes? Then does he have to make rain checks for people? What does this even mean? So that's not generally going to be an offer when you see something like that. Perhaps this could be when you say Bob's Shoe Depot, Nike Metcon 5S, so it's specifically identified shoes, that it says 75% off. We have a date. Here it says while supplies last. So that's sort of a limiting factor, because we can say basically that, well, it's addressed to people who come in who want to buy this particular shoe at this particular price, and there's no problem of over acceptance because once he runs out, he runs out. So it's not like I could call up and say, well, I accept. It's like, well, no, you have to come in and you buy it. If I run out, I run out. If you want it, come in. It's while supplies last. That may work. It may be specific enough under the circumstances to count as an offer. So, but it's very factually dependent. And we'll see. I mean, the classic example is the fur coat case where the shop says, if you're the first in line on Saturday morning at 9 a.m., or the first three in line at Saturday morning at 9 a.m., then you can buy a fur coat for $1. And so there, it's very specific. You know, I have to be in line at 9 a.m. I'm one of the first 3 people. So there's a way to identify who the offerees are. We know the price. We know that who the parties are. So we know the department store that's selling it. We know that it's a fur coat. And we know that what needs to be done to accept it, which is be in line, have the dollar ready to go. So that would work because it's very specific and it's very limited. So that's the classic example. This one here is relatively close to that, somewhere between, I would argue this may tip in on the side of being an offer. Well, that's everything. I hope that's helpful. And as always, if you found it helpful, please like, subscribe, tell your friends, and I will see you next time. Thank you very much. Talk to you soon.